So good morning, everyone, and welcome to our week 8 colloquy. This is the part that we are recording live in Toowoomba. So again, we are still continuing with our coverage of contracts. This is part 3 of your textbook. And here in Toowoomba today, we're going to do chapter 14. Later in the week in Springfield on Thursday, we're going to do chapter 15. And we'll finish off again in Toowoomba next week, chapter 16. And continue with chapter 16 in Springfield. So next week, hopefully, we'll finish off on contracts. And then the last week, which is week 10, we will cover one chapter, which is chapter 19 on agency theory. All right. So just to reposition ourselves. So we have gone through the first analytical structure where we talked about the existence of a contract. We said there are 3 elements. The first being agreement. The second, intention to create a legally binding relationship. And the third was consideration. And we said sometimes a simple contract might not need consideration because of something called promissory estoppel. Then we talked about the validity of a contract, and we looked at 3 elements already. So we looked at the full capacity issue, or the element of capacity. Then the element of consent, including things like mistake, for example. And looked at legality, and in particular, things around restraint of trade clauses. The last thing that's left here then is form, okay? And there's just a simple note on form, and I just want to make sure that you see that in your textbook. Sorry. So we want to look at what kind of form you require for certain types of contracts, okay? Some contracts, if they don't have the correct form, are going to be void, okay? This idea of a contract becoming void because of a problem with the form. For example, some contracts require to be written in writing. So if they are not in writing, then they are void, okay? Which means that you can't take them to court. But sometimes they could be still valid, okay? They could still be valid, but still unenforceable. So you can't still take them to court either, okay? Not because they are not valid, they are valid, but because they are in a certain form that's different from what's required by statute, okay? We'll look at that. So if you go to your textbook, pages 199 to 100, you'll find that they talk about form as the 4th element of validity. So we said there are 3 elements on the existence of a simple contract, and 4 elements as to the validity of a simple contract. This is the last one, okay? So there are 2 categories. A contract would be void, okay, unless in writing, in certain types of contracts. So on page 199, you'll find that they talk about a number of these contracts. Okay, so on page 199, they give you like 4 different types. But I just want to emphasize the real estate contracts. Okay, real estate contracts need to be in writing. Okay, one example is that in Queensland, but of course you'll see that there are similar acts in the other jurisdictions. Okay. So that's the first type, where a contract is void unless in writing. So if it's a real estate contract, it has to be in writing. Otherwise it's void. Then the second type is where you have a valid contract, okay, but it's unenforceable. There's a valid contract, but it is unenforceable unless in writing. Okay? An example of that is this case from Pavey. I think we're getting interference. So there's a case on page, so Pavey is on page 416. I'll leave that for you to go through. But it will explain more how a contract could be valid but still unenforceable. Okay? And there are also important types, in particular the sale of a land, okay, land sale, okay, which is exactly the same property law act that I referred to in the previous section, but these are in the previous category. These are sections 56 and 59. Another category is where you have a sale of goods of a value of a price of $20 or more. Okay? But this is in two jurisdictions. So you'll find that in Western Australia and Tasmania, they have something called the Sale of Goods Acts. Okay? Just like we have also in Queensland. But those acts, okay, tell us that if you have a good that's of more than $20, then there has to be a form of writing. So they say that has to be evidenced in writing. Okay, so that's what you will see on page 200. Okay, just remember that in some jurisdictions, if you want to buy and sell a good with a price of over $20, you will need to evidence that in writing. Otherwise, the contract is unenforceable. Okay, so I'll leave it there. That's all I have to say about that. Go back and look at pages 199 to 200. It's a very good idea that you have that as well as part of your notes for the final exam. All right. So, as we said, so far, we started on contracts from week 5. So far, we came to find that our contract exists. That's the existence analysis over the 3 elements of agreement, intention, and consideration. Then we found that our contract is valid. So we looked at the 4 elements of capacity, consent, legality, and form. What now? So do we have now a contract? Yes. Is it valid? Yes. But there are still some other issues that could arise. So all that this says is that the contract that you have, okay, is something that you can take to the court. So enforceability is available. Okay. So now you want to enforce this contract, okay, and that would create a different set of issues that we will find in chapter 14. All right. So the first thing I want to just re-emphasize is the difference between a representation and a term. So you find, for example, when we talked about negligence, we discussed something called negligent misrepresentation. And there were 2 other types of misrepresentation. We said fraudulent misrepresentation and innocent misrepresentation. But remember, we said that those are misrepresentations or representations because they are outside the contract. Those were statements that induced you to enter into the contract, but they are not terms of the contract. So enforcing the contract has nothing to do with that. Okay? If you are going to go and get any remedies in terms of compensation, you will have to argue something outside contracts, okay? Like fraudulent misrepresentation, okay, the tort of deceit, or the tort of negligence, in particular negligent misstatement. Okay? So a representation is a statement of fact made by one of the parties, but it's before entering into the contract. Okay? It doesn't become part of the contract. Okay? So representations are pre-contractual and do not form part of the contract. So they are not actionable in common law. Okay? However, remember, of course, that now you have the ACL, which means that there are sections like section 18 of the ACL that would make something like misleading or deceptive conduct a head of action or a cause of action you can take to court. And also remember that if you can't do something about that under contracts, you always have the other possibility under civil liability that we've studied at least, which is tort law. So if it doesn't fit into contracts, you can take the misrepresentation and argue it, for example, as a negligent misrepresentation. Okay? But if you can prove that that statement of fact is in fact a term of the contract, so you can see it in writing in the contract, there's a clause that says, for example, you have to do something, or that whatever you are going to supply me has to have certain characteristics, then that's a term of the contract. And you can go and sue on the contract itself, breach of contract, and say that this term has been breached. Okay? So that's a statement of fact that's intended to be legally binding and is part of the contract. So I remind you again, so we teach these things in silos, so now you need to remember that these things are connected. So please go back and also look at what we talked about in terms of misrepresentation in chapter 12. So that's in pages 308 and the following pages. But also go back and remember that we talked about this in chapter 6 when we looked at, or chapter 5 and 6, when we looked at negligent misstatement. Yes?
What was the second one again? It was representation and...
So we're talking about the difference between a representation and a term. If it is a term, we say that you will find it in the contract, and then you can use contract theory to argue that there was a breach of contract, and that would be the cause of action under which you will argue for compensation, because it's part of the contract. Sometimes, however, this statement of fact that we're talking about, okay, and we'll flesh this out soon with examples, could be something outside the contract. So you can't go and argue that there was a breach of the contract because it's not part of the contract. So what do? One way to do that is to go through and look at how we looked at misrepresentation, because there are 3 headings under misrepresentation. There's negligent misrepresentation, innocent misrepresentation, fraudulent misrepresentation. Okay? So you can look at, for example, other torts like deceit or negligence, in particular negligent misstatement. Okay? So an exam situation, okay, you will have to argue both sides. Okay? That's the fork in the road. You can't just simply say, oh, this statement is a term. If it's not clear, so if the exam question is written in a way that makes it possible for you to argue both sides, then I expect you to say, well, if we can argue that this is a term of the contract, then we can go under this breach of contract and look at the breach of contract remedies, which we'll talk about in chapters 15 and 16. Or you could say, maybe it's not a term of the contract, it's a misrepresentation, okay? And then we can look at it under those other headings. All right. How do we know? Whether a statement is a representation or a term will depend again on the intention of the parties. This is not new to us right now. Yeah, we have talked about intention since we started looking at torts. It's always about the intention of the parties. And our job, you know, as legal analysts or the court, is to discover what that intention is. What do the parties intend? What did they intend when they entered into the contract? Okay. Over time, you'll find that this is more and more now becoming an objective test. Although there are 2 actually theories under contracts. There's one subjective theory, it's losing ground, and more we'll talk about this objective theory. So it's an objective test, meaning what? That we substitute a reasonable person. That's what we mean by objective, and ask, would a reasonable person have intended this when they entered into the contract? Sometimes, of course, it's a mixed. Okay? Sometimes it's a mixed objective-subjective test because you also need to look at the facts in the case. So, we look at certain factors. Okay? This is what I mean by the factual matrix. So the court is going to look at some factors from what happened between the parties to establish whether this factual statement was intended to be a term or a representation. So these are on pages 349 and 350. The first is time between the statement and agreement. Okay. So we'll look at some examples, so I'll leave that till then. But sometimes if the statement is made just before you enter the contract, then that's more likely to be a term of the contract than if the statement was made long before entering into the agreement, because that's the negotiation phase. So that's really a representation, not a term. Or if you were asked to check the statement, okay, that establishes that if you are going to check the statement, then that's not really a term, because if you're not happy with the statement, then you're not going to enter the contract. It's something about getting into the contract rather than being part of it. Intended to mislead. So if the statement is actually made with the intention to mislead you, okay. Or importance of the statement. Okay. So if the statement is important to you, that gives us an indication that it is really a term of the contract. It is something that you value so much that if it's broken or breached, then you're not going to go ahead with the contract. Sometimes also we look at the special skill and knowledge, the imbalance between the parties. So if one of the parties knows more about something than the other, and they make a statement of fact, then that statement of fact is more likely to be actually an inducement rather than actually a term of the contract itself. We'll look at some examples. All right, leave that now and move on to something called collateral contracts. Okay. So sometimes we find that the statement of fact is in fact not part of the contract. We said that another venue for you to look at is misrepresentation. So that comes under torts, either negligence or deceit or innocent misrepresentation, for example, the ACL. But yet there's another way you can actually analyze that statement through something we call a collateral contract. So that's not the main contract we're talking about, but it's really legal fiction where we say that there's another contract that's connected with the main contract. Okay? So where a pre-contractual statement, so pre-contractual, it's not part of the contract, okay, is not a term of the main the main contract, it may still have contractual effect as a collateral contract, thus providing the injured party with a remedy. And a collateral contract has an independent existence from the main contract, and the collateral contract is not caught by something we call the parole evidence rule. So it's one of the exceptions to this rule, which we will discuss in just a minute. Okay? So basically, this is legal fiction to try and help you get a remedy around this statement that was made to entice you or induce you to enter the contract, and it's not part of the contract. How can you collect on that? How can you get damages for that? So there's this legal fiction where we say there's a collateral contract, and it's that contract where this statement is a term, and that contract has been breached, not the main contract. We'll look at that with some examples. All right, let's look at the parole evidence rule. Without an E, parole without an E. So we're not talking about parole in terms of getting off early because of good behavior. We're talking about parole, so the French parole, which happens also to be with an E, which means words or oral evidence, words evidence. What does this rule say? It's a rule of evidence. Okay. It says in the case of a written contract, the court generally will not admit evidence of acts or words of the parties prior to the execution of the document. So something in writing, we signed off on it, and these things happen before doing so. The court will not look at that. If it has the effect, if these things have the effect of adding to, varying, or contradicting the written agreement. So once we have a written agreement that's signed off, then the court makes the presumption, okay, that everything that the parties intended is caught by that written document. They are not going to admit any other evidence from anything that happened prior to getting to that point, to signing this document. However, as everything in law, there are exceptions. One exception we just looked at was the collateral contract. The collateral contract, the theory of collateral contract, is an exception to this rule, but there are also other exceptions. So if the evidence that you're trying to bring to the court is about trade, custom, or usage, okay, that would be admitted. Or show contract not effective. So the evidence is really trying to show that this contract is not effective, then that kind of evidence the court will admit. Okay. Court of opinion, written document contains only part of the contract. So you can convince the court that the contract is not captured by only one document. There are many different parts of the contract, and what is captured by the written document is only part of that contract. That's the argument you present. If there's ambiguous language in this written document, then again, you would be arguing for bringing evidence outside the written document to explain what that ambiguity is. Sometimes mistake. Okay? So sometimes when we write a document, we make a mistake in relation to price, for example, okay? Or in relation to other things, terms, in relation to terms to the contract. So you are able to bring evidence to explain what that mistake is. Okay? Or again, if there's false description in the contract, so in a way similar to mistake, but sometimes there could be intention involved. So, in a nutshell, if there is a written document, okay, and there is a statement of fact that you want to rely on, okay, that could either be in the document or outside the document, you have to think about whether that statement of fact is a term of the contract, even though it's not within this written document, or a misrepresentation. If it is the latter, then you'll have to go and look at things like tort or theories like collateral contract to try and argue that there's a different contract under which I can collect or ask for remedies. If it is all in this written document, in this written agreement, then you cannot bring any other evidence except in these circumstances. Okay, so let's then dig a bit deeper in relation to terms. So we said there are terms, there are representations. Let's say that the statement is a term. So what kind of terms do you find in a contract? Two types. They could be express. So like saying the price is $20. That's a term of the contract, and it's express because you can see it expressed in the contract. It's expressly stated. Sometimes the contract, the term is implied. Okay? So you go and look at the contract, there's nothing there. It's not in the contract. But it could be read into the contract. Okay? Either by the parties or by the courts. And when are we going to be able to do so? Well, things, for example, trade customer usage. Okay? We looked, I think, here on Springfield at one of the cases where there was a trade custom for selling skins, fur skins, and the trade custom was you sell it by piece. Okay? But there was a mistake in the contract, and they put something like skin as something per pound. So it was actually stated by weight. So that's what we mean by implying a term. You can go to court and argue, but in this trade, in this industry, we sell skins by count, by piece, not by weight. So the trade custom could be implied in the contract. So the court could say, yes, we agree with your argument, and in this case, the contract should have been stated as dollars per skin, not per pound. Sometimes the implication could be by statute. So you could go to the statute and find that in certain statutes they explain to you what kind of terms should be in the contract. As well by the courts, sometimes because of equity. So they can come in and say that this term should be implied. Okay? Like sometimes there are implied warranties. And of course, after the ACL, you'll find that most of this is now captured by the Australian consumer law. But under common law, you could also argue that there's an implied warranty for certain outcomes from the goods or services that you are buying. And sometimes because there are uncertainty in the contract, so the courts would actually imply the term so that that uncertainty is resolved. Again, all of this is an abstract, so we'll look at some examples soon. In order for you to be able to imply a term, there are 5 conditions. Okay? The term must be reasonable and equitable. Makes sense? It is necessary, so you don't just imply terms. So again, the idea of efficiency. We will imply a term, but it will be implied only if it's necessary. Okay? So if you can have a contract that's effective without this term, the courts will not imply. Okay? There's no need to read that into the contract. It must be obvious, of course. You don't want to include or introduce new ambiguities or uncertainties. Must be capable of clear expression. Again, it's the same thing as number 3. And must not be in contradiction. Must not be in contradiction of any express terms in the contract. So again, the idea that when you imply, you want to make sure that the final document, the outcome, is going to be clear and non-ambiguous, and there's no uncertainty. All right, so all of this will make more sense soon, hopefully, when we look at some examples. Let's then talk quickly about another distinction between something called conditions and something called warranties. So we started looking at two different things. We said we have a statement of fact, but we don't know whether the statement of fact is part of the contract or not. Okay? If it's part of the contract, we say it's a term of the contract. If it's not, we say it's a representation or a misrepresentation. Okay? We said if it's a term, then that term could be classified as either express or implied. Express or implied. Now we're digging deeper under express terms. So it is in the contract, you see it in the contract, but it could still be one of these two types. It could either be a condition or a warranty. Okay? Now remember, if it's a business to consumer contract, okay, it would come under the ACL, so Australian Consumer Law, which means that it will have a different classification in terms of guarantees. This is really more towards business to business. So if you have a contract between two companies and they end up arguing about something in the contract and they don't want to continue with the contract because of a breach of that term, then they start asking themselves and arguing in front of court whether this thing is a condition or a warranty. Why is that important? As you can see, a condition is essential to the contract. Okay? So I need to make sure that you deliver this thing to me within, for example, in early October. I need that because it's going to go for as an input to another process, like manufacturing process. So I need it delivered by the 1st of October, let's say. To me, that's essential part of the contract, because if I don't get it by the 1st of October, I'm not going to be able to enter this into this other process that I'm doing, which means that, for example, I'm going to lose a contract, or I'm going to be hit by a penalty because I'm not going to deliver on time. That's what we mean by essential. If this condition is essential, this term is essential, so the term is what? The delivery schedule. I want this to be delivered by the 1st of October. That's the term. Okay? And why is it a condition? Because it's so essential to me. If you don't deliver on it, I will lose something else. Okay? So if you don't deliver, I will cancel the contract. And that's what it means really. It means that you can rescind the contract. If you fail to deliver on an essential term, what we mean, what's a condition, then I have the right to go to court and say, I want to cancel this contract. I don't want to go ahead with this contract anymore. Plus, arguing for damages, so you also can ask for monetary compensation. You can either cancel the contract or ask for monetary compensation. This is only if it's a condition. So if it's a warranty, it's of lesser importance. Okay? So I still want you to deliver on the 1st of October, but I'm not too worried whether you bring me this thing that I'm asking for delivery of by the 1st of October in for example, boxes of, I don't know, 60 pieces or boxes of 100 pieces. So I expect that you will deliver in boxes, but I'm not too worried whether you bring those boxes in 40s or you bring those boxes 100 apiece. So that's a warranty. It's of lesser importance. Okay? So that will not allow me to turn around and say, I don't want this contract anymore. I wouldn't be able to rescind the contract, but I would still be able to recover money, compensation. Okay? So the only one that will allow you to get out of the contract is the condition. We'll look at some examples. Okay. So you see, it's only a term, an express term, okay, that's capable of being a condition or a warranty. Okay. So again, we started with that bifurcation. We said there's an option that a statement of fact could be a term or it could be a representation. Then we focused on terms, and we said they could either be express or implied. And now we're focusing about focusing on express terms, and we're saying they could either be conditions or warranties. And how would you know? Again, what's the test? Just like the test for distinguishing between a term and a representation, you have to look at the intention of the parties objectively. So the test, like everything in law, the test is in red, whether it appears from the general nature of the contract, looking at the contract as a whole, or from some particular term or terms that the promise is of such importance, okay, to the promisee. There's a typo there. That they would not have entered into the contract unless they had been assured of a strict and literal performance of the promise. So the promisee, of course, is the person receiving the promise, and this promise is so important to them. What's the promise? Promise, for example, that I will be delivering these boxes to you by the 1st of October. It's so important for me, okay, that they wouldn't have entered the contract unless they had been assured of strict and literal performance. So had you told me before entering the contract that actually I wouldn't be able to do that, I wouldn't be able to deliver on the 1st of October, I would have said then I'm not interested in contracting with you. I'd go find someone else who would give these to me on the 1st of October. Okay? Now there are elements of this test. Like everything else we said, you have to look for the elements. What are the elements of this test? Can anyone tell me what the elements are? So of course they are the ones highlighted or underlined. So you have to show that you would not have entered into the contract unless assured of strict and literal performance. And the second is that it has and ought to have been apparent to the promisor. So the person who is actually promising me to bring me these boxes by the 1st of October can tell that these are so important, that this condition, that's so important to me that you deliver these on the 1st of October. Otherwise, I wouldn't actually contract with you. So it's obvious to the promisor how important this is to me. And I wouldn't have entered unless assured of that performance. Literal, strict and literal performance. All right. I know it's all in the abstract, but we will come into the examples very soon. Let's talk about exclusion clauses then. What is an exclusion clause? So it's sometimes referred to as exclusion, sometimes exemption, okay, or exception, or limitation of liability. So what's happening here is someone is going to enter into contract with you, okay, but they're afraid that something could happen that will open them to liability. Okay. So they would put a clause, a term, an express term, okay, in the contract saying that we are not liable. Okay. And the issue, of course, is this term effective? So if something actually happens, can they rely on this term and this clause and say we're not liable? Or can you still get damages out of that? So we can look at two different cases. The first is the one where you have a signed document. So the contract is a signed document. In that signed document, there's an exclusion clause. So they are saying we are not liable for damages or things like that. So unless they have committed fraud or misrepresentation, okay, so you have to establish either fraud or misrepresentation, otherwise you're bound by that. So if you sign a document without reading it, and in that document there's an exclusion clause saying we're not responsible, then they are not responsible. Okay? Unless, of course, there was fraud or misrepresentation. The other possibility, the other case, is where you have an unsigned document. So there was a contract, but I haven't signed anything. Okay? And then there's a test to see whether this exclusion clause will have an effect or not. Again, it's an objective test, no surprises there. So it brings in the reasonable person. So we would ask, would a reasonable person have expected to find such a clause in that type of document, so what a reasonable person would expect, and have reasonable steps been taken to give sufficient notice to the person of this term? If not, can they be implied by trade or custom? So, you're given a ticket, for example, but on this ticket there's this term, there's this exclusion clause that says we are not liable for damages, say, to dry cleaning. When you received this ticket, okay, or receipt, you didn't think that there would be any contractual terms on it. Okay? So you didn't agree or disagree. So unless they bring that to your notice, okay, that exclusion of liability is not effective. So they are still liable. Okay? Sometimes, for example, you take out books from a library, yeah, public library, but there's a fee or fine when you are late on renewing or returning the books. So if that fine is exuberant, you know, so it's like $1,000 a day, of course that's not reasonable. So they have to bring sufficient notice to your attention before you take the books. Otherwise they can't turn around and say, oh, but there's this term that you have to pay $1,000 per day, because it's not reasonable. So unless they bring it to your notice and you say, yes, okay, I'll still take the books, that wouldn't be effective. Now, if we incorporate this clause after all of this, so we say, okay, there is this exclusion clause, I can see it in this contract. Now the courts are going to try to interpret this contract, this clause, to see whether it actually is wide enough to capture the scenario or the situation at hand, whether there is liability or not. When they do so, the construction exercise is going to go through certain number of interpretation rules. One of them is called contra proferentum. Contra proferentum simply means against the party who wrote this clause. So I'm the business, I'm the party who prepared this, say, pro forma contract. It's pro forma, so it's a form and you just sign it. And I'm the one who wrote this clause into this pro forma contract. Then if I go to court, or the person takes me to court, then the court's going to look at this pro forma contract and look at this exclusion clause and go and say, I will construe this, but I will make sure that it's done against the business. So it's going to be narrowly construed. So they will try as much as possible to find you to find you liable, okay, unless the construction, which is very narrow, is still going to give you that ability to say, I'm not liable. We'll look at examples as well. Last thing I want to talk about is this third party. Okay? So there is an exclusion clause in the contract, okay? But what effect is it going to have? So a third party is generally not protected by an exemption clause, okay? Unless there's express intention by the contracting parties to cover this third party. So again, it's all about the intention. If an exemption clause excludes liability for all terms of the contract, the courts will strike down the clause as there's nothing left in the contract. This third-party exemption clause is a different point. It's called the Himalaya clause, okay, from the case that it came from. If there's a third-party exemption clause in the contract, okay, that can provide protection to a third party to the contract, and that's what we call the doctrine of privity of contract. Okay. So this is on page 379. Okay, that's on page 379, and we'll look at some examples. Now, the last thing I want to say about exclusion clauses is that there's an ethical structure, just like we had for the existence of a contract or the validity of a contract. If you are faced with an exam questions that shows you that there's an exclusion clause, you are expected to do two things. First of all, you have to look at whether this exclusion clause is incorporated in the contract. So is it part of the contract or not? Okay. And we looked at things like, for example, whether it's a signed document or unsigned. Okay. If it's an unsigned document, whether there was, sufficient notice and a reasonable person would expect to see it there. But after you've done with that, you go on and interpret the clause through things like contra proferentum. Don't forget as well the effect of the ACL, just 1 or 2 pages in your textbook. That's all what I'm after. So we just want to see that you can say something about the ACL in your answer. Okay. Let's then go back and look at some examples. Let's start from Oscar Chess, and that's on page page 250. So, William's mother had purchased a second-hand Morris car, okay, 10 saloon, believing it to be a 1948 model. So they bought a car thinking that it is a 1948 model. In 1955, the car was traded for a used car. It was traded into a used car dealer. The car's appearance and the registration papers supplied by Williams indicated that it was a 1948 model. The plaintiff based the price, so this is the car dealer, on the current price for such a car in a guide, cost glasses guide. So this is dealer's guide that was used to determine approximate value and the price of the car at the time. However, the car was in fact not a 1948 but a 1939 model, okay, which was of course discovered later on. So the dealer sued Williams some 8 months after the sale when it discovered the alteration in the registration papers. There was an alteration in the papers. Okay. So this, for example, could be an exam question. The facts are your exam question. Your job in the exam is to come up with this issue. That's the legal issue. Then after that, you would have to go through the law, application, and conclusion. So the issue, the legal issue, was the statement as to the age of the car, a term of the contract, given that one of the parties had special knowledge or experience as a car dealer. So we said that the court looks at some number of factors to decide whether a statement is part of the contract or not. What is the statement in this case? Well, the statement in relation to the car make, the year the car was made. The statement that the seller gave was that this car was made in 1948. And the question is this statement part of the contract, a term, or is it simply a statement of fact that's a representation, and at that it's a misrepresentation? Why is it a misrepresentation? Because the car was in fact made in 1939. Yes? How can you decide whether this statement was part of the contract or simply a misrepresentation? Okay? One of the factors they look at, as we said, is the special knowledge and expertise of the parties. So this is what we talked about. Okay? We looked at whether we can decide whether a statement of fact is a representation. So we wanted to decide whether a statement of fact is a representation or a term, and we said that depends on the intention of the parties. Okay? So how do you discover this intention? You look at some factors. The factor that comes up in this case is the last one. Okay? Whether there is an imbalance between the parties in relation to their knowledge, in this case about cars. So who has more knowledge?
The dealer will have more knowledge.
Williams or the dealer? That's what we are looking at. And why are we looking at that? To see whether, in this case, the intention of the parties was to have this statement of fact in relation to the make of this car, the year, a term or a representation. Okay.
Wouldn't it be that the dealer was lying about the year of the car so he could sell it for more money, or?
So it's not the dealer who was lying, it's the seller who was lying. Okay?
Oh, right. Well, that's what I'm saying.
Yeah.
Wouldn't the seller have lied? Couldn't they argue that the seller lied about the
Yeah.
year of the car so
Yeah.
he could get more money?
So let's assume that they have lied. How does that change the knowledge calculus? How does that change whether the dealer should know more about the car than them or not? So I come to you with a used car, okay, and I say to you, oh, this, and I even alter the registration papers, and I say this is, for example, a 14 car instead of a 2010. Now you are a dealer. So what do you think should happen here? What a reasonable person would expect?
I guess a reasonable person would expect that the dealer should do a background check on the car.
And they would be able to
and then they could actually
ascertain whether it is a 214 or 210. That's what we're talking about. So regardless of whether we say this was an innocent misrepresentation or a fraudulent misrepresentation, so whether Williams knew that the car was a 1939 or 1945, that doesn't change the fact that as a reasonable person, I expect the dealer to know more about the car than the seller. Okay. So how did they go about doing the analysis? So they said the statement as to the age was a mere representation. They decided it doesn't come into the contract. Okay, why? So it didn't give rise to any liability for breach of contract. Why is that? Because the plaintiff, who's the plaintiff? The dealer had special expertise as to motor vehicle, as a motor vehicle dealer, and should have taken steps to verify the age of the vehicle if it was in doubt about its true age. So the key point is the expectation again, should have. So you can see the similarity with something like we talked about in terms of contributory negligence. It's like they're saying you were negligent. You should have actually looked into this. And now you come turn around and say, oh, they tricked me into thinking that this was a 1945 car. You should have known. That's your job. That's what the court is saying. Okay. Now, that's the point you were making. In the textbook, they focus on only one interpretation. Okay. So they're saying the dealer or his counsel didn't think thoroughly as to how they bring this to courts. This was an old, of course. This was 1957. They're saying you should have thought about the strategy better. You could have argued that, Your Honor, this could be a term of the contract, and if I fail on that argument, then I would like to argue in the alternative that it was a misrepresentation. And under misrepresentation, I could argue it was an innocent misrepresentation or a fraudulent misrepresentation. So I could argue that Williams actually are the ones who doctored or tampered or altered these registration papers. Or I could argue that it was simply an innocent misrepresentation. Okay. However, they say the failure here, again by this dealer, to act promptly. Because remember, they waited for 8 months. Again, why would you wait for 8 months? Okay, meant that it lost the right to have the contract set aside in equity. Because remember, if it's innocent, you can look at making it voidable under equity. Of course, today, and in Australia, I also expect you, if this was an exam question, to bring up the issue of the ACL, whether the ACL would be relevant here or not. In the exam question, for example, we could say something like, instead of 8 months, they just, the next week or the next day. How is that going to change your answer? The next day, they decided that, oh, they discovered that there was this problem with the age of the car, and they started talking to Williams and then decided to go and sue them. How is that going to change your answer? All right. That's enough on this part. I want to go to collateral contracts. Excuse me. Let's go to page 352. I'm going to look at two cases. The first is De La Salle and then J.J. Savage. So this is talking about collateral contracts. I want to explain how this idea of collateral contracts could be construed, or how you can build an argument for a collateral contract. So De La Salle and Guildford entered into a lease. Okay. Before signing the lease, De La Salle had asked Guildford whether the drains were in order. So this is for a house. They want to lease the house, but he wanted to check about the drains. Okay, are they in order? Because in his previous house they were blocked and he had been flooded out. So he had bad experience with the stuff. He wants to make sure it doesn't happen to him again. Okay. Guildford told him that the drains were in good order. Is that a promise? Is that a statement of fact?
Well, it later says that there were no terms in the contract to that effect, so I...
No, I'm asking you, is that a promise? When someone asks you, are the drains in order? And I say, yes, the drains are in order. Am I promising you something?
Yes.
Yeah, I'm making a promise. The promise is what? That these drains are in order. Is that a statement of fact? Yes, it's a statement of fact. What's the fact? That the drains are in order. But the question, of course, is that statement of fact, is it a term or not? So as it says, there was no term in the contract to that effect. Okay, so you are a business student. Okay, and you want to go and get a lease. And it's important for you that the drains are in good order. So you inquire about that. Okay? What do you think is going to happen next?
It just says the drains are faulty and...
No. If you want to go into the lease. So from experience, I know people, for example, who just recently moved into a house, okay, a lease on a house, new house, and they had an issue with the bedroom, the master bedroom, okay, and the wife asked whether they could have some drapes there. Right? And they were talking to the real estate agent, and the question was, because there are 3 rooms, 3 bedrooms, and the wife was actually saying, I need to have these in each bedroom. But the real estate agent was talking about the master bedroom because they were standing in the master bedroom. So they signed the contract, the lease, and then later on, the real estate agent went and spoke to the landlord, and then they came back with, one proposal for the master bedroom. What about the other bedrooms? They said, oh, we never promised you that. So these things happen all the time. So I'm asking you, as a reasonable person, not even business, as a reasonable person, what should you have done?
We should have read the contract a bit thoroughly, and more thoroughly.
Not just read the contract, but they should have asked the real estate agent to put that in the contract. So at the bottom, we would say, on the condition, not warranty, condition. So if I don't get those, I'm out. They didn't. Same thing here. Why didn't he put that into the contract? What's the hurry? Why not? 1901. So I hope by 2017 people think differently now. The drains, however, were faulty. Okay? Moreover, the lease that he signed said that the tenant, it was his responsibility to keep these drains in good order. So he got flooded out again, and now he has to pay for all the damage. The landlord has nothing to do with it, right? That's what he signed off on. Legal issue. What is he going to try to do, of course, as LaSalle? LaSalle is going to try to get out of the contract. He's trying to get out of the contract. The defendant, could De La Salle rely on the statement, i.e. the drains are in good order, as to the condition of the drains? So, what he's trying to say? This statement is part of this lease. It's a term of the lease. Not just only a term, it's a condition of the lease. So if it's a condition of the lease, I get the right to rescind this contract, meaning I can cancel the contract and I'm out. And I don't have to repair anything. That's what he's trying to do. That's his argument. So how did they try to do that? The first thing was what? Was this statement part of the terms of the contract? No, because it exactly told us that up here. The statement that the drains are in good order is not in the contract. There was no term in the contract to that effect. You go and look at the contract, there's nothing about the drains. What am I going to do now? How can you help De La Salle? So that's the legal fiction when we say, aha, that's the main contract, that's the lease contract, but there is a contract before that, which is a collateral contract, which was about what? About the condition of the drains. So, can you flesh that out for me? What is the collateral contract? So someone said that it was about the condition of the drains. We know that a contract is about what? An exchange of promises. Okay. So De La Salle, or actually Guilford, promised me what? So Guilford gave me a promise that these drains are in good order. Remember, because it's a contract and it's a simple contract, I have to buy that promise. I have to pay consideration for that promise. What was De La Salle's consideration? What did he pay for that promise? Huh? The lease money, you said he signed the contract. Yes? Do you understand that? So let's do it one more time. There are two contracts here. That's why we call it the collateral contract theory. So something like this. So there's K1 and K2. So K1, okay. So let's call K1 and K2. Contract 1, contract 2. The first contract was between De La Salle, let's call them L, okay, DL, De La Salle, and G for Guilford. Okay. Again, the first contract was what? That Guilford promised De La Salle about the drains. Right? The drains are in good order. What did De La Salle promise Guilford? Promised him K2. He promised to enter into that contract. What is K2? Again, De La Salle and Guilford. So De La Salle promised the lease, and Guilford promised the lease. De La Salle promised the money or the rent. Okay? So that contract, K1, is what we call collateral. A collateral contract. All right? So, they said that the defendant, Guilford, was in breach of an oral collateral contract. So this is legal fiction to make sure that De La Salle, because it's unequitable, you know, that they don't get any compensation. Okay. Today, of course, you have the ACL that could give you a different route to argue in relation to the drains and what kind of guarantees should be in that lease. Sometimes when you go around Toowoomba, you will find that a lot of the houses have security grills. You know, they have a security grill, so it's like a metal, steel,
The wire door before the actual.
for example, or on the windows. Yeah, many of the new units that are being offered as lease units, okay, don't have that. Of course, because the landlord don't want to pay that extra cost. They want to recuperate on the investment as soon as possible without having to put up all of these things. Okay. The other issue was the NBN. So the broadband, a lot of these houses as well need some setup. So you'd have to pay something like $500 to set up and the landlord is not going to do it for you. So all of these things should be remembered in terms of when you want to enter into a lease, but also what other sort of venues for compensation could be open to you here in Australia in 2017. So if you get something like this in the exam, all I'm saying, remember as well what happened since 2000, I don't know what year this was, 1901 and 2017. Okay, so you have to talk about things like the ACL and so on. All right, let's look at Savage.
So you're saying even if every time we look at one of these conditions, we have to think, would this happen in today's society?
If it happens in today's society, what else would come into the picture? You know, we have the ACL. Okay, that's enough actually. If you just remember that there are other things that you have to look at, if this is something that you're looking at today. This is a case from 1901, 1970. But you have to think of it, of course, when you're given the final exam question, it's not going to be, oh, this is 1901. It's going to be 2017. Okay. Blackney entered into contract with the defendants for purchase of a boat. During the course of negotiations, okay, Blackney sought the written advice of the defendants. Okay, so this time it's a written advice, which you might think is a better thing, right? So as to whether this boat, okay, about the suitability of the engine of the boat, so they commented on 3 types and recommended one, okay, that included the statement that the boat would have an estimated speed of 23 kilometers per hour. This is still negotiations, so they're looking at what kind of specifications they're going to have for the boat that they are going to build for him and he's going to buy from them. So they made a recommendation, and under that recommendation it said that this kind of engine would have a speed estimated at that 23 kilometers per hour. So the buyer accepted, okay, but the contract specification, again, why? Okay. And quotation contained no reference to speed. So in the previous case in La Salle, it was an oral inquiry about the drains. This time it's not oral, it's in writing. You would think, oh, this is in writing, it's better, right? Let's see. Again, after the motor was fitted with this engine, the boat failed to reach that speed that they estimated. Okay. Was the recommendation of the speed of the boat capable of being considered promissory? So they're asking us, this statement that was in writing in this letter, saying that this engine has an estimated speed of 23 kilometers per hour, is that a promise? It's a statement of fact. Yes, it's a statement of fact. But is it a promise? Are they promising you that this engine is going to have a speed of 23 kilometers per hour?
I'd say it is because they've literally said that they wait.
Yes, Luke. So what is the first thing you're going to look at is the thing between quotation marks, right? Because that's the statement we're looking at. That's what we want to analyze. Estimated speed of so-and-so. Now, is this a promise? What is a promise? So when I go and test it, it's like science. When I go and test it, you know that I'm going to get that speed. Right? That's the promise.
Well, yes, but I'm just saying that it goes back to when there was no contract specification, but it does say that the defendant did recommend this motor and they said to have an estimated speed of 23 kilometers per hour. That doesn't mean it's going to have exactly 23.
So is that a promise? Am I promising you that it's going to have a speed of 23 kilometers per hour? No.
Because you're
So-
only saying estimated, not them
Correct.
saying exactly that it could be a promise.
And that's the issue. They looked at the boat and they said that the boat failed to reach this 23 kilometer per hour speed. Yeah, because it's an estimate. But they still sued. You know? A good counsel would have told them not to do so because it's obvious that they were not promising you. So where's the mistake? When you sign contracts for things like this is probably the hundreds of thousands of dollars. It's just like buying a house. What is the first thing you're going to do when you have a contract in your hand? You're going to go and give it to a lawyer. So they can look at it and see if there are any, issues around things like this. In fact, it's a good idea to actually get the lawyers involved early on in the negotiation stage so they know what you're looking for, what's important for you, and so on and so forth. Of course, if these are companies, and that's usually the case, they have what they call in-house lawyers. Just like this university, for example, has something called the legal office. So they look at all of these contracts for you. All right, let's speed up a little bit because I want to have a break and then we'll start on our tutorial. I want to jump into Lestrange on page 368. So we're looking at exclusion clauses. And we're going to look at this case from 1938 from the UK. Lestrange bought a vending machine from Colloquy, okay, and signed a document headed Sales Agreement. The document was an order form containing a number of clauses that Lestrange failed to read. Like everyone these days. Of course, to make sure that you fail to read it, I'm not going to give you one page, I'm going to give you 1,000 pages. Go and read. Even better, I'm going to put it up online, and it's going to be a click wrap. Something like, just click and you say, or tick, agree, and who's going to read it? Okay? It's getting worse these days, not less. Actually, people are reading less these days. And they give it to you in very small font. All kinds of stuff.
And again, it's like 10 pages long. You're like,
yeah, always. No one reads these things. I can assure you. Whenever you buy something online, or something actually wrapped, so you buy something online, it comes to you, and they say, by opening the wrapping, you agree to the terms and conditions. What is that?
That means as soon as you're opening it, you've agreed.
You know what I'm saying? Who's going to read these things? Yeah.
That's the thing. Like, I don't think anyone reads any of their
So
updates.
that's what I'm saying. All that's happening these days is that less and less people read. All right. So when the machine failed to work properly, of course, she brought an action. So when we say brought an action, when you look at your assignment questions, that's what we mean by action. They're looking. So she brought an action against Colloquy alleging breach of fitness for purpose. Okay, this is something, of course, you'll find now as a guarantee under the ACL. Okay, GrowCorp failed on a clause in the agreement that said, so this is where we're going. This is the agreement clause. So you'd go and highlight all of that if it's an exam question. And that's what you're going to focus on for your analysis. What does it say? This agreement contains all the terms and conditions under which I agree, okay, to purchase the machine specified above. This is a form. It's a pro forma contract. And any express or implied conditions, statement or warranty, statutory or otherwise, not stated herein, is hereby excluded. So it's a very wide exclusion clause. What are they excluding? Liability. Okay. So again, it says, this agreement contains all the terms and conditions. Okay. Any express or implied conditions or statement of warranty, statutory or otherwise, not stated, is excluded. So the issue was, remember, this is a signed document. We said there are two types here. This is the one that's signed. Okay. So given that Lestrange had signed the document and there was no evidence of fraud or misrepresentation, was she bound? Now, if you recall, we said that when it comes to this type of documents where they're signed, okay. In the case of signed documents, it says at the bottom, unless fraud or misrepresentation can be established or there is statutory protection available, the signer is bound. So today, of course, there will be statutory protection under the ACL. Okay. But this case, of course, is from 1934 from the UK. So you will not see that they talk about that there, but you will find it, of course, maybe as a comment. So, as there was no fraud or misrepresentation, she was bound. Okay. Irrespective of whether she read the document or not. Yes?
Question, do you think that a lot of businesses make contracts these days so long and hard to read that they know people will just sign them without reading them or something?
So you'll find a lot of people have already started doing research on these things. Yeah. So in, for example, the University of Chicago, there's a guy called Omri bin Shahar who has actually already 2 PhDs from Harvard. But the guy actually looks at that very particular point. He says, you know, you look at any of these pro forma contracts today, and they're so long, and it's just ridiculous, you know, who's going to read them? So he's asking for regulatory reform so that we can stop doing that. So we want actually to stop having companies issued so long kind of contracts. And he's saying, just abolish all of that, you know?
Just get to the point.
Yeah, so make it very super simple. And regardless of whether you put that or not, to be quite frank with you, no one is going to benefit from it. You know, neither the company is going to benefit, nor the customer is going to benefit, because again, no one's reading it. Now, of course, the company is not necessarily trying to defraud you because they have their reputation online. So an Apple, for example, when they sell you something online, like for example, a software or mathematics or whatever, you know, you want to buy a software package online, you know, that's their reputation online. You know, when they actually promise you something, that's why people don't read, you know, because it's really a form of trusting this brand. So they know that I will keep buying from it. Or if you go to the Apple store or, you know, Google Play, yeah, that's why people don't read, because they know that, you know, I can trust this brand. But yes, sometimes it could be something that has to do with trying to defraud. I don't think it's always the case. So the decision basically illustrates this parole evidence rule that we talked about, okay, and the limitations placed on something non est factum. Remember non est factum? We talked about non est factum when we talked about consent in terms of mistake. No? One of the types of mistake, non est factum. Italian folks, couple. All right. Okay, I'll leave the reflection for you to look at. I think I'm gonna stop here so that we can have at least half an hour of the tutorial, and we should be back here by 10:30, please. So half an hour for the tutorial. Come back at 10:30, please.